Hello and welcome to Sable International's Citizenship webinar series. Today we're going to be discussing children under 18 and British nationality. Just a little bit of housekeeping. If you'd like to expand the presentation or the presenter's view, there are some arrows on the top right-hand corner that point away from each other to make it bigger, or if you want to make the speaker panel bigger, there's a plus and minus button which you can use accordingly. We also have a chat function on the top right-hand side of your screen. That's where we'll have the Q&A session at the end of the presentation. Please, if I can ask you, I'll post a format now, but when you do ask questions during the Q&A, if you can please use the format that has been posted on the chat at the moment. We will then see your information and we can answer your question accordingly. There's also a poll that we have running that will see what, if we could, interesting to see what the closest link is to you to the UK. We'll go through those results a little bit later. Just a little bit about Sable International before we get started on the presentation. Sable International started in 1995. We have offices in the UK, South Africa, and a presence in Portugal, along with offices in Australia. We have 6 core services that we specialize in and believe that these core services encompass vital aspects of our clients' needs that they have when investing offshore or moving abroad. These services are citizenship, tax, foreign exchange, residency by investment, wealth, and accounting. The presenters for tonight, my name's John. I'm the Sales Director of Sable International Citizenship and Immigration Division. We have Philip Gamble. Philip is the founder and senior partner at Sable. He trained with the Home Office within their Citizenship Directorate until 1992 and is widely regarded as the foremost authority in the world on British nationality law. We also have Michelle Patel. Michelle was born in Mombasa in Kenya and relocated to the UK in 2004. Michelle joined Sable International in 2009. He's registered with OISC, and Michelle specializes in isolating claims to British nationality for those who have connections to former British territories or colonies. So without further ado, I'll hand you over to our presenters to start the presentation.
Okay, thank you very much, John. I'm Philip Gamble, as you've probably heard from my colleague John, and I'm going to talk to you about how to claim British nationality for your children who are under the age of 18. So without further ado, I'm going to move on to some general points which you need to know and understand before you start looking at claims for citizenship. So first and foremost, we need to look at age. So the age of majority in the UK is no longer 21, it's now 18 years of age. And it's important to know that there will be only certain avenues open to children whilst they're under the age of 18. And if they go past that age before any sort of application's made, then you're in a position where the entitlement may potentially be lost. Another key aspect of this is sort of the timing. It's no use coming to look at this perhaps a month or a week before the 18th birthday. You need to do this in good time. So the more time you have, the better off you will be, and the chances could well be better as well. The other thing that we need to understand before we go forward is it's not good enough when looking at a claim by descent from a parent to know simply that that parent is British. We have to know if that parent is either British by descent or otherwise than by descent to see if that citizenship can pass down to children born overseas in any country whatsoever now. So it's not simply enough to know that the parent has a British passport. Being British by birth doesn't necessarily just mean being born in the UK. There can be other circumstances which will lead to a parent being classified as British otherwise than by descent. So it's quite a complicated area, and we always recommend getting professional advice if a child's about to turn 18 and to make sure that no entitlements are lost for that particular child. Okay, so moving on to another general rule, and this is simply about generations, first and second generations born outside of the UK. So on the slide in front, you'll see that we have there grandparent born in the UK, parent born outside of the UK, grandparent born outside of the UK too. So generally speaking, but not always, there are many exceptions to these rules. The first generation born outside of the UK is going to be British by descent. That's the parents in this particular example, and will normally have a direct claim to British nationality. A grandchild born outside of the UK is not normally British by descent, but don't let that worry you too much at this stage, because there are plenty of exceptions that apply to this, and we're in a position where we're going to go through some of those in slides for you tonight, so you can see some practical examples of how that citizenship by double descent, if you like, so that's 2 generations born outside of the UK, can work. Okay, so starting effectively with the most straightforward situation for a child, which would be where that child is born in the UK. So we've had a key change in British nationality law on the 1st of January 1983. Before that date, if anyone's born in the UK, they're simply British by birth. There are pretty much no exceptions to that rule. Child born after the 1st of January 1983, so by definition, someone who is effectively a minor now, or hopefully a minor now, is only going to be British by birth in the UK if we're in a position where the parents themselves has a British passport, is a British citizen, or holds permanent residence. So it's very similar to the rules in other countries of the world, notably South Africa. So a parent born in the UK now is not going to be British unless one of the parents is either British themselves or holding the permanent resident status. There are a couple of other varieties of applications which can be made to secure citizenship for a child born in the UK who doesn't meet either of those criteria. So effectively where the parent is not British at the time, and that is where the child has been born in the UK and has spent 10 years in the UK from the point of birth, and an application is made for that child to acquire citizenship. That application can either take place before or after the 18th birthday, or where the child is born stateless. So if a child's born in the UK but doesn't pick up the nationality of one of the parents, those children are going to have a right to apply for British nationality through a formal application. I must apologise about the slides. There seems to be some sort of technical glitch here. They seem to be jumping around a little. So if you can go by what I'm saying rather than the slides themselves, that will probably bring us back into parity here. So the next thing that I'd like to take a look at is where a child is born to a British parent, but where the child and the parent are born outside of the UK. So it's not necessarily a second generation claim as such in the context that we're looking at here, but we're looking at where the parent is actually naturalized. So we've talked about how you acquire citizenship by birth. Another way in which a person acquires British nationality is through a process called naturalization. So that's a formal application to the Home Office to naturalize as a British citizen. So many people from Commonwealth countries particularly came to the UK in the past. They've spent time here, they've worked in the UK, and whilst they're here, they may well have decided to become British because they've come on ancestry visas, let's say, and they've acquired a residency, and they then naturalize as a British citizen thereafter. Where a person naturalizes as a British citizen, the position is just very simply that the child will be British automatically by descent, regardless of where they're born. So a child born to a naturalized British citizen in South Africa or any other Commonwealth country is very likely to have a direct claim to British nationality now. So that's one example of where a person, a parent born outside the UK could be a British citizen now otherwise than by descent. And that puts us in a position where we can move on to another practical example, which we term as where the parents registered. So naturalization is a formal application to acquire British nationality. Registration is another form of application to the British government for someone who's not British to acquire British nationality. Now, before the 1st of January 1983, the UK citizenship law was relatively, well, it was all stacked in favour of the male line. It was not possible to claim British nationality through the female line under any circumstances. So this obviously had to change. The change came about on the 1st of January 1983. And effectively from that point, a citizenship claim by descent can come either from the mother or the father. So a child born outside the UK after 1983 can claim through either the mother or the father automatically, whereas before 1983 they could not. So the changes were first announced in the UK Parliament in 1979, that the law was going to change and it was going to be made gender equal. From that point, applications were invited to persons born to British mothers before the date when the law actually changed, which was the 1st of January 1983. And the applications were termed as registration applications. So the practical example of this could be where a person is born in South Africa in, let's say, 1970. Their mother happens to have been born in the UK. They didn't get citizenship because they couldn't acquire citizenship from their mother in the female line at that point. And so an application was allowed from February 1979 for that person to become British by descent. Now, you'd be forgiven for thinking that that person who's then registered as a British citizen, the parent, would be British by descent themselves because they've claimed it through their mother. But that's not the case. A person registered between the dates of the 19th of February 1979 and the 1st of January 31st of December 1982 will be a British citizen otherwise than by descent, so the parent can then pass citizenship to a further generation born in South Africa, born after 1983. So it's another great example of what to look out for. So if you're the parent of a child born overseas, if you've been naturalized as a British citizen or if you've been registered after 1979, then there's a good chance that your child may have a claim to British nationality now. Another variety of this is effectively where a child is born stateless. So we talked about that stateless children being born in the UK and having a right to claim citizenship on that basis. What we're looking at here is perhaps if the child is born outside of the UK. So statelessness occurs where the child is born in a country which doesn't always give citizenship by birth. So these countries are quite widespread around the world. I mean, a good example for South Africans would be Dubai, where effectively perhaps a South African couple living and working in Dubai, if they have a child born up there, that child is not going to be a citizen of the United Arab Emirates. They simply don't give citizenship to people born who are not originating from that country. So if you happen to be let's say, having a child born in Dubai, we're looking at the male line, the father's born in Zimbabwe and the paternal grandfather's born in South Africa, you're possibly going to get a position of statelessness there where the child doesn't pick up any nationality. Anyway, the point here is where a child's born outside of the UK and a child's born stateless, if that parent is British, then a registration entitlement for the child comes in if there's a further 3 years residence in the UK. So it's a solution which requires UK residence for 3 years, but is not an automatic one and requires an application before the 18th birthday. Okay, now another typical example of citizenship by, if you like, double descent in the second generation by descent is where the middle generation, the parents, has acquired citizenship by descent, but has spent time in the UK themselves in the past. So if you picture this scenario: a grandparent born in the UK. The claims in the mother's line that the mother's born in South Africa, but the mother has spent some 3 years in the UK in the past, perhaps as a student or perhaps as a long-term working holiday maker, or just to get some experience over here. This was very popular for Commonwealth citizens in the 1980s and the 1990s. And that length of residence is at least 3 years. She then goes back to South Africa. There's another generation born over in South Africa, and that child is under 18 at the point of application. That child can have a claim to UK citizenship as well. So grandparent born in the UK, parent born in South Africa, and child born in South Africa, but the parent has spent some time in the UK in the past, 3 years we're looking for here. It can be sometimes shorter, it can be as little as 2 years and 3 months on occasions, but other rules apply to that sort of calculation, which have to be done on an individual basis. Then claims to citizenship exist. So parents' residence in the UK or previous residence in the UK is extremely important. Another variety of this is if the parent hasn't spent time in the UK, but the family decides to relocate back to the UK and clock up at 3 years residence after the child's birth, that will also give rise to a claim. So 3 years residence for a parent in the UK before a child's birth is very good. 3 years residence for an entire family having moved back to the UK where the parent's British by descent is also very good indeed. Okay, so that's a few scenarios that we have by citizenship by descent. I appreciate there's lots to take in here, and you're listening to someone talking on a number of different areas, and I think a lot of this will become clear at the Q&A session at the end. However, in the meantime, I'm going to pass you over to my colleague Michelle, who's going to talk about a few other options that are available for citizenship by descent for children born outside of the UK. Okay, over to you, Michelle.
Oh, thanks, Phil. That was very insightful. I'll take over for the next couple of slides before we hit the Q&A session, guys. So my slides talk about something a little bit more complex, and I'll try and go as concise and slow as possible. There is a slight delay on the slides, so it will take some time for the slide that I'm talking about to come up, and just bear with us. We have, I think, close to about 1,000 people on the seminar. So the slide you see in front of you is called Citizenship and Renunciation. And the reason why that is we come across cases where we've noticed that British citizens perhaps who were born in the UK or are British citizens by descent because they're born to parents who were born in the UK are faced with the sort of issue where they have to renounce their British nationality in order to maintain or take up a local form of nationality where they're living. I think one prime example of that, and many of you on this webinar might also be from that country, which is Zimbabwe. So we see a lot with Zimbabwe, we see that a lot with Kenya. And traditionally, you'll know that these countries had very strict sort of dual nationality restrictions. So this slide covers a possible route to register a child under 18 at the time of the application, where through the work from this firm and to the Home Office, we may be able to agree with the Home Office that they'll register a child at discretion if it can be proved that were it not for that parent's renunciation, i.e. had that parent not renounced, then the child would be born to a British parent, and the child therefore would be entitled to either British citizenship automatically or by a formal application. So just a modern day sort of discretionary provision where we use now and again, where we convince the Home Office to register a child on the basis that were it not for the parent's renunciation, the child will be British. But for this, you would obviously need to know how that relevant parent became British. Assume the renunciation never happened, and had that been the case, would that parent been able to pass on that nationality? And is the child under 18 at the time of the application, which is obviously relevant. So if you are someone that has a child born to them who is still under 18, but at the time of their birth, you had renounced your British nationality and have subsequently resumed or could resume, which we can confirm, then this slide may be applicable to your child. Of course, there is a deadline of the 18th birthday. A special mention on this slide is also we noticed a sort of perhaps an unintended consequence of a child being registered in this fashion leaves this child actually British other than by descent. So meaning if a child is registered under this provision, in most cases, the child's then able to pass on British nationality to their own next generation born out of the UK. So just one of the most weird ways in which British nationality works. So to the next slide. So the next slide is labeled citizenship and gender discrimination. Again, work that was originally pioneered by Mr. Gamble and the Home Office led to a concessionary provision which exists in the modern day, which means a child under 18 can be registered as a British citizen if it can be proved that the only reason that child does not qualify was due to the fact that their parent could not claim their own British citizenship down the female line. So in other words, if you're a parent who, for example, had a mother born in the UK, and as a parent you were born before 1983, then you'll know that traditionally you have not been able to claim your mother's nationality. But in the modern day, a provision does exist allowing you to register as a British citizen. Of course, if you were to register as a British citizen now, you'd be a British citizen in the modern day, not at the time your children were born. But the way this policy works and this slide works is if you were to assume you were British all along and there was no gender discrimination, would your child be British? And if the answer to that is yes, then we can formulate a way where we can register that child whilst they're under 18 as a British citizen through this route. Of course, things to look out for are legitimacy, etc., and so on. But again, it's not the end of the world if you become British in the modern day, is the point I'm trying to get across, because there are these provisions. Again, special mention that a child registered in this fashion becomes British other than by descent, so they can pass it on to a further generation born out of the UK, whereas traditionally that wouldn't have happened. So that's quite nice. The next slide is one that's quite interesting, has come up a lot in the last few years. I noted that there was a gentleman called Adam who's posed a question, which Adam, if you're hearing this, then this is quite relevant to what you asked, which is adoption in the most normal circumstance. It does not really lead to British nationality automatically. It's quite rare where it does, even if the adopting parent was, say, born in the UK. And that's usually because most adoptions we see or we come across, the adoption process has happened out of the UK, not whilst the child is in the UK. But over the past few years, through some work that this firm has done and the policies of the Home Office, we have been able to register children who have been adopted by British citizens who themselves became either British because they were born in the UK or were British because their relevant father or mother were born in the UK, and that British parent then spent, say, 3 years in the UK before they adopted this child. So in other words, we're trying to level that playing field where we're trying to force the Home Office through many of these applications, and we have successfully done it so, to treat an adopted child the same as a biological child, because really no distinction should exist. And we believe strongly in that. So if you are someone, Adam, that was born in the UK and have adopted a child, and your child is under 18, and you've always had British nationality, then it would be worth getting in touch with us, because we would really love to so work on those cases. Again, special mention to the fact that this child ends up being British other than by descent, so actually gets more rights to pass it on a further generation to their own children, no matter where they're born. Now, the next 3 slides will cover a scenario where actually none of the previous slides have really applied. And there's no immediate claim you feel that your child has, but a relocation to the UK is on the cards. You really want to pay attention to those next 3 slides, which will cover 3 relocation scenarios. So the first scenario here we have is a family that's obviously outside the UK, specifically both parents are British citizens, or one parent's a British citizen and the other parent holds permanent residency of the UK, indefinitely to remain, or even is an Irish citizen, which are automatically considered settled in the UK at the moment. So in this particular case, we have 2 British parents, for example. A child who is under the age of 18 can relocate with these parents who are considered present and settled in the UK, and this child would get indefinite leave to enter. Now, indefinite leave to enter the UK is basically a visa-free status. In other words, there is no expiry date on their status or how long they can remain in the UK. A child who enters in such fashion would normally be eligible for British or registration as a British citizen at the third or once they've completed 3 years residing in the UK along with their family. But even if they choose not to and they return back, their permanent residency sort of stays intact as long as they're entering the UK before a 2-year period from the last time they enter the UK expires. So we find this quite useful to know this, because if you are someone, a young family, and you're both British parents, you want to come into the UK and pick up at least a permanent residency, then you can do so. And then once a child is over 18 and say comes to the UK to study a university course, they can go ahead and naturalize as an adult, because at least now they have their permanent residency, which is usually the first step to becoming British. So that's one scenario because of the two British parents. The next slide there, we'll just wait for that to change, and I think it just has. So in this case, we have a child that's under 18, where at the time of the application, which is what's relevant, and where the parents both do not have British nationality, which I think covers sort of 80% of the scenarios I'm looking at in terms of the questions coming in. So you got one parent who, say, for example, is South African, the other parent's British by descent, because they are born out of the UK, but their relevant parent is born in the UK, and the child is 6-7 years old. In this scenario, if you were to move over to the UK and your child, you and your other half were to remain in the UK for a 3-year period, in some cases even less, then your child can be registered under a specific section in the current day. And this section leaves your child British other than by descent, again, giving that child the ability to pass on their nationality a further generation, even if that generation was born out of the UK. Now, in this case, I think the important part to note here is that the child would have to be under 18 at the 3-year mark, or once a family have completed residing in the UK for 3 years. So if you enter, say, after the child's 15, then that's a little bit too late. Not necessarily not able to do anything, but it will be difficult to get them to do that. Now, also within this 3-year period that the child is in the UK and the parents are in the UK, each parent and the child have to adhere by strict sort of residential requirements where they must not be out for more than 270 days in the relevant 3-year period. Okay, now the last one of these 3 scenarios, and we see this also coming up on a sort of monthly basis. It's very similar to the previous slide, bar the fact that we have a single parent here. So it could be that the single parent is a British citizen parent, and the other parent has either passed away, divorced, or separated. In this case, again, it's not impossible to bring the child over, and if the sponsoring parent or the parent coming over, i.e. the British parent, has sole custody and sole responsibility for the child, i.e. takes the day-to-day and the major decisions for that child, then that child could again get indefinite leave to enter, come over to the UK, and then once a 2 or 3 year period has been spent with that relevant parent in the UK and the child is still under 18, then you can register that child as a British citizen. But the important part, and I think the most difficult part for most people in this particular position, where the single parent who holds British nationality and want to relocate with that child, is to prove the sole custody and the sole responsibility for that child. And we usually, as a firm, do an assessment to confirm whether we think that the parent would have the sole responsibility if it's not covered by the relevant court papers. But again, if that's something that appeals, then you should get in touch with us and we can advise further on that point. I think that's all from me. I'm going to pass you over back to my colleague John, who will take you through the next couple of slides. Thank you for listening.
Thank you, Phil. Thank you, Michelle. Very informative. A lot of questions coming through, and the main one is, does my child have a claim to British nationality? Just before we go to the Q&A session, I'll just explain a little bit about process and some ways that you can get in touch and how we can, other than answering your questions tonight, is give you our opinion. There are some free options where you can get initial advice from our consultants. You can email them or call them. There's WhatsApp functionality on our website. You can contact them, give them your details, or via Facebook, and they will get in touch with you. One thing that we will be asking everybody to do is complete our online assessment. It is free and it is relatively quick to complete once you have all the information. I am going to post the link to that assessment now on the chat functionality. So when you have time, you can go through and put in the details. That information will look at your family tree and it will allow the specialist to give their opinion on your child's chances of getting British citizenship. Obviously, with this scenario, you're looking for citizenship for your children. So when you complete the online assessment, if you can complete it as yourself, and you can put your spouse and your children in the relevant fields. It won't accept just your child as they'll be under 18. Then, once you've gone to that, there are the options where you'll be paying a fee. It's if you want a formal phone consultation with a specialist in the UK. You can have a phone consultation with one of our presenters, Michelle, for £120. And then there's the status trace, which is once you've done the assessment and you want us to give you a formal written opinion, whether your children or you have a claim to nationality, UK nationality or not, that is where we will charge the fee. So just a quick breakdown of the assessment. Once you've given us the information, you will get one of 5 answers. The one is you have a definite claim to UK nationality. We will move you on. We can go straight to an application and we can assist you with that. The other option could be remote, which means it is very unlikely that you will have a chance to citizenship, and we wouldn't encourage you to explore it any further. It might be a waste of your time and money. Then you can have one of the other 3 options once ordering our British passport review. That is a likely claim to British nationality, which puts you in a 90 to 95% chance. Unclear. We possibly need more information from you. Maybe the family tree was incomplete, or there is something where we have a question. If you are on that unclear, we can go to the phone consult, get that information for you for the £120 before maybe, and then get the answers from there, or you can just speak to one of our consultants on email or the phone. There's also the option of unlikely, where it's 5 to 10% chance of claiming citizenship. We have found a number of people that have had an unlikely claim. They've done this trace, and once you've spent the time going through their family tree and the nationality law, it has come out that they have a claim. But like I said, your chances are 10%. Roughly, we found with people who have unlikely as a response. If you get a result of likely or unclear on the British passport review, we will then move on to the status trace. That status trace is £350, and the aim of that status trace is to give you one of 2 answers. Either you have no claim, and we will end the search for you there, or we find there's a claim to British nationality, and we'll advise on how best you can move on to or to proceed in obtaining citizenship for you or your children. Included in that is if you have no claim, and or even if you have a claim to British nationality, we do look at other nationalities, for like the EU, for instance. If you have any links to any of the EU member states, we can give you our opinion on that. And then, of course, if there's no claim and there are immigration options like UK visas, like the ancestry visa or the spousal visa, we can give you information on that and help you with the applications from wherever you are in the world. And now onto the Q&A part of the evening. As Michelle mentioned, there are a number of people that are on the webinar today. The questions have been coming through thick and fast. There's a lot of interesting questions, a lot of interesting scenarios. So I'll pose as many of them as I can. Michelle and Phil will try and answer all of them. If we are unable to get to all your questions, we will send this video to you afterwards via email. You can go through the slides, see what applies to you. You're welcome to do the online assessment. Once you order the review, one of our consultants will be in touch. You can also email, phone, WhatsApp, or get in touch and get in touch with us on Facebook, however is most convenient for you. So moving on to the first question, it's Caitlin. Caitlin, it was born in South Africa in 1985. She has 2 children, aged 1 and 3. Caitlin does have a UK citizenship. She doesn't say how, but she says, are you saying we need to move to the UK and live in the UK for 3 years before they turn 18? Can we return to South Africa after those 3 years?
Okay, I'll take that one first. So Caitlin, I'm not sure where your parents were born, but I'm assuming as you're born in South Africa, you've got perhaps a father or a mother born in the UK, so you're British by descent. Okay, so assuming that's the case, you've really got a couple of options. So if you haven't been to the UK and stayed here in the past, stayed here for 3 years, then there's probably not going to be any automatic claim to UK citizenship for your children. One thing that we didn't touch on in the seminar, which I should touch on, is about government service. There is another exception where a person born outside of the UK to a father who's in UK government service, that could be the government of the UK or a colonial government of the UK in Africa perhaps, and affects lots of people born in Zimbabwe, then again you get double descent options which apply. So you do also need to look out and see if your ancestors have worked for the UK government in any capacity. Going back to your children who are 1 and 3 though, assuming you are British by descent, if you do relocate back to the UK now and before the children are 18, so you can get an application in before their 18th birthday. So realistically, that means you've got to be in the UK before the 15th birthday of your eldest child. Then an entitlement to UK citizenship would come in for your children on application and after the 3 years residence here. With those applications, the whole family has to come back, and so it would be the children, you and your husband, unless you're divorced from your husband and are a single parent as such. So it's the children and the parents have to be in the UK for that 3 year period. Then an application would become possible at that time. So if you can't do that, you're born in South Africa, so I'm assuming your kids have got South African passports as well at the moment. You also have a possibility for an ancestry visa when the children have come of age. So if you can't relocate to the UK or you don't want to, it's not practical, for whatever reason, the children would still have a right to relocate to the UK using the ancestry visa once they become adults. That gives 5 years leave to remain in the UK. And at the end of the 5 years, permanent residency, and on the 6th year, an entitlement to naturalize as a British citizen, provided that certain residence criteria are met, not being out of the UK for too long, primarily there no more than 90 days a year. So yes, you've got the option of coming to the UK as a family now, staying here for 3 years before the kids are 18. That would work. Equally, if you can't do that, and assuming the ancestry visa is still available when your kids are adults, they could come in under their own steam later on as adults and acquire citizenship in their own right. Okay, hopefully that covers your question there.
Thank you, Phil. The next question is from Lara, also in South Africa. In 1978, her father was born in the UK. Her mother was born in South Africa. Her maternal grandparents were born in South Africa, and her paternal grandparents were born in the UK. So her question is, I hold a British passport and lived in the UK for a period of 2.5 years, traveling between the UK, South Africa, and America. So it wasn't constant. Would her children be eligible?
Okay, so for Laura, I mean, yeah, absolutely. I think her prior UK residence is probably the most crucial. Sometimes a less than a 3 year period can work if you're if you haven't exhausted the sort of, allowance as such, which was 270 days, that the parent could be away from the UK and still have that intact 3-year period. So if I was to just take this 270-day period and go, well, I haven't used any of it, or I've used X amount of it, then we could add the unused allowance to make up a 3-year period, which, it is a bit complex and technical, but it's not completely, it is completely doable, and we have done it in the past, and it has sort of reaped some success. But I think it all boils down to that, and the children obviously being under 18 at the time, because what we're looking at here is a registration, which I think Philip covered in one of his slides under section 3 in brackets 2. But apart from that registration, I can't see anything automatic here for her children. So it would all come down to whether we can compile a 3-year period as such before the children were born, and the children are going to be under 18 at the time we take that ahead and apply on the children's behalf. John, all right?
Yep. Okay. Thank you very much. Laura, get in touch, possibly complete our assessment or email, and we will chat to you further. The next question is from Mangesh. Was born in India in 1980. His wife was also born in India. He says they have 2 children that were born in the UK, and Mangesh and his wife hold Indian citizenship only.
Okay, do we know when the children were born, John?
There's no dates, unfortunately.
Okay, so we'll assume that they're under the age of 18 now. Mangesh, if the children are born after the 1st of January 1983, which must be the case here, there's no automatic entitlement to British nationality by just simply being born in the UK anymore. So this goes back to the first principle we were talking about. A child born in the UK now is only going to acquire British nationality if one of the parents is either British or holds the status of a permanent resident. Now, I can't say what your visa status is in the UK, whether you're still here or whether you return back to India again. But in the event that you had indefinite leave to remain, the UK's version of permanent residency at the point the children were born, they will be able to apply, or they will have a direct claim to British nationality. On the other hand, if you didn't have permanent residence when they were born, but you later acquired that status, then there's the ability to make a formal application before they're 18 to become British citizens now, and that can take place regardless of where you are in the world, whether you're still in the UK or whether you've returned back to India. The only other provision which might be of interest to them there said if they've just spent the first 10 years of their life in the UK after being born here, and they haven't been away for 90 days in any one of those 10 years, then again, a formal application would be possible to be made for the children, regardless of where they are in the world now. So it all depends on what status you had when they were born. If you didn't have the permanent resident status when they were born, if you acquired it later, you can still make an application, regardless of how long you were in the UK for. Or alternatively, if they spent the first 10 years of their life in the UK, an application is also possible. If you were born in India, I suspect the kids are Indian by descent in the first generation, so there probably won't be any case in terms of statelessness. I hope that's answered your question.
Thank you, Phil. So the next question is from Mark from Canada, born in 1971. His mother and father were both born in England in 1935. All of his grandparents were born in England.
Yeah.
His question is, I know I automatically can get British citizenship through descent, but what about my children?
Yeah, I mean, and I assume, John, he hasn't spent any time in the UK that he indicates on that text.
He didn't say.
No. Okay. Well, Mark, if you're still on the webinar, I mean, you would, as you rightfully put it, be British by descent. So, on the common rule that you couldn't pass it on a further generation born out of the UK. Now, of course, the exception here would be if you had spent some time in the UK, ideally 3 years, then we could register any children that are under 18 at the moment as British citizens. But if you haven't spent that time in the UK, then you couldn't, there would be no immediate claims for these children to get British nationality through you or through what we know so far. Relocation will probably work out best if the children are young enough and they're going to be under 18. Say if you were to relocate and they would, you spend 3 years here, would they still be under 18? Then that could be on the cards, and you could design a route so that the children pick up British citizenship, sort of having spent 3 years in the UK in the near future. But if you haven't spent time in the UK in the past, then I think it probably is unlikely. Obviously, we don't know what the mother side is, but I'm assuming there's no British citizenship there. Yeah, thanks, John.
Okie dokie. Moving on to Kimberly in Canada as well, born in 1963. Again, both parents born in the UK, both sets of grandparents born in the UK. She has citizenship through her parents and she lived there for 2 years. Can her 17-year-old daughter get citizenship?
Okay, so again, this is another classic situation of a claim or potential claim to citizenship in the second generation by descent. If I heard you correctly, John, I think you said that Kim spent 2 years in the UK. Is that correct?
Yeah, she said 2+, so a little bit over 2, it looks like.
Yeah, 2+. Okay, so generally speaking, you need 3 years, as you probably saw from the slides, to make a claim effective for any children born to you overseas, Kim. If you want to reduce that period from 3 years down, then, as my colleague Michelle explained earlier, then it is possible, but only where you're able to make up any shortfall in the residential period by unused allowance for absences at the time. So the allowance for absences at the time is 90 days a year, or 270 days in total. So that's 9 months approximately. So the minimum time you could spend in the UK would be 2 years and 3 months, but that would only work if you've not spent any time outside of the UK whatsoever. So if you've been in, let's say for, think of a good way of explaining this. If you've been out of the UK for any time at all under that scenario, it wouldn't work at all. Alternatively, if you're in the UK for 2 years and 4 months, but you'd spend a month outside of the UK, then that would probably work. So it's based on a calculation of whether you can use any unused time from the absence allowance, which is 90 days a year. So this is because the law which surrounds this says that you have to be in the UK at the beginning of the 3-year period and not the end. So you can use any unused absences from the 270-day allowance to make up the period. I hope that makes sense. It's not an easy concept, but it's something, if you'd like to take it up further, us would be delighted to have a look at.
Okay, great, thank you. The next question is from Mary, born in Hong Kong in 1968. Mary acquired British citizenship through naturalization, 1997. She said her husband is holding a BNO, and her parents and grandparents were born in Hong Kong. Her daughter was born in Hong Kong in 2009. Is it possible for her daughter to apply for citizenship?
Right, yeah. I mean, that's slightly different there for Mary, because if she was born in Hong Kong in 1968, chances are she's picked up British nationality at the time she was born. And I think perhaps she was registered as a British citizen through sort of the selection period that sort of happened before Hong Kong was handed over to China in 1997, perhaps. So we would have to examine her certificate of registration as a British citizen. So this is Mary's, to figure out whether did that certificate of registration render her British by descent or British other than by descent. So once we know that, then we know whether the children she already has are British at the moment, or can they be registered as British citizens, perhaps? Now, in my view, that would take us looking at the certificate and confirming where she lies. Is she by descent or other than by descent? Because there were many provisions at that point where, PNOs were changing over to full British citizens, either as the main person or just a member of the household. And therefore, each certificate has a different effect on how that person is classified, either British by descent or other than by descent. So I'm sorry I can't give you a confirmative without looking at that certificate and confirming what section he was issued under. But obviously your daughter is born in 2009, so we still have some time. She's way under 18. Now you mentioned your husband's a British national overseas. Um, of course, at the moment you would have heard that, if the other guys are resident in Hong Kong, that there is a visa category that's bringing BNOs over for those resident in Hong Kong to come into the UK. Again, I'll be happy to discuss a potential future route for the family to come in if there's no immediate claim. So please get in touch, Mary, and perhaps we can have a consultation on how we go ahead and confirm what those steps could be or what they look like. All right.
Excellent. Thank you,
just to add to that,
Sure.
Marianne, if you did acquire British nationality through the selection of the 50,000 key personnel in Hong Kong in the lead up to the handover in China, you will probably be British otherwise than by descent, and should be able to pass that nationality to a child born overseas. Equally, if you've used the correct term or you were actually naturalized in the UK, the same thing would apply. But if you were naturalized as what we call a British dependent territory citizen in Hong Kong before the handover, the same thing probably wouldn't apply. So it is quite a complex area, as Michelle said, but there's certainly some options there.
Great, thank you. Moving on to Shelley, born in Northern Rhodesia in 1962. Her parents were both born in South Africa. Her maternal grandparents were born, maternal grandfather born in the UK, maternal grandmother born in SA, and both paternal grandparents born in the UK. Her daughter will be 18 in October this year.
Okay, is it clear whether Shelley's got a British passport or not at this stage? Or is she in the process of getting?
Neither. I don't know. I don't have any of that information.
Okay, well, being born in Zambia in 62 is normally quite fortuitous for people in terms of a direct claim to British citizenship themselves, particularly where the paternal grandfather's born in the UK, and I think that is the case here, isn't it, John, if I'm not mistaken?
Yes, I just want to say, so Shelley says she has a British passport.
Yep.
And sorry, what was your question there, Phil?
Paternal grandparents are born in the UK, I'm assuming.
Correct, both of them.
Yep, okay. And no UK residents in the past mentioned?
Nothing mentioned.
No, okay, that's fine. So although, Shelley, you were born in a place which was actually came under the British at that time, because of course Northern Rhodesia is a British protectorate. Traditionally, it's part of the Federation of Rhodesia and Nyasaland, actually, at the time you were born, which was an independent Commonwealth country for the purposes of British nationality law at that particular point. So there's no claim to citizenship by birth here, and it makes it, the long and short of it is you become a British citizen by descent with the changeover in the law in 1983. The only exception to that would be again if your father was in Crown service at the point you were born, which is possible, and it's something we could take a look at. Those cases are few and far between, though. So I think you have to assume that you're British by descent, and so your children will have no automatic right to UK citizenship unless there's something on the father's side or their father's side, your children's father's side, in terms of a grandparent being born in the UK. They won't qualify for an ancestry visa either when they become adults. So you can get an ancestry visa if you've got a grandparent born in the UK, but not a great-grandparent, as might be the case here with your children. So that leaves you really only with the option of relocation to the UK before the children are 18. That could be done in a number of different ways. If they're young enough to come to the UK and for you to clock up 3 years residence as a family before the 18th birthday, then there could be an entitlement to citizenship at the end of the 3 years. If, on the other hand, they're already, let's say, past the age of 15, and so can't get 3 years residence in the UK before they're born, they can still accompany you as your dependents if you decide to relocate, and work their way through to a residential status, probably from 5 years from the point you come to the UK, provided that they remain part of your household, so they're still your dependents as such. So you'll be able to get them into the UK. If they're able to stay for 5 years, if they're over 15, then they'll have a right to residency, a probable right to residency at the end of that time, and citizenship in their own right as adults. Or if they're under 15 and you can get into the UK to settle as a family and clock up 3 years before the 18th birthday, then they would equally have a claim. Okay,
Sorry,
John.
Phil, she is widowed, so it would just be her.
Okay. Yep. So it's effectively just the children and you, Shelley. Okay. That is.
All right. The next question is from Andrew from San Diego, California. His mother and father were both born in Scotland. He says he'd like to get UK citizenship for himself and his 15-year-old son that was born in the US. How can he prove how long he stayed in the UK continuously, is his question.
Right. Well, I think so. Am I right to sort of, John, am I right to take it as he doesn't have British nationality at the moment or doesn't have a British passport, he says. So he's like to arrange that as well. Right, yeah.
Yes.
Yeah, so Andrew, I mean, being born out of the UK to a father that was born in the UK with you know, hopefully we don't have anything to say that you know you were born out of marriage and so on. So the British nationality from your father would most likely pass over to you at the time that you were born. Only thing that really stops that is one, you know, you're born out of a marriage. Number two would be if your father was born in the period before 1949 and naturalized as a US citizen in that period as well. Then there could be a situation whereby he may lose his British nationality even before you were born. But you know, of course, we would look into that in detail for you. But assuming none of those things matter, then you have been British since the day you were born, Andrew, and you are a British citizen at the time your child was born, bar the fact that you are probably what we call a British citizen by descent. So you couldn't automatically pass it to your child. Now, of course, if you have spent time in the UK, which you seem to have, then there are many ways of trying to evidence that. And I guess it's not the correct platform to go into it in too much detail. But with most people, either they've been here very young or they've been here studying. So, for example, if you're here studying or working, one could just go ahead and get a a statement for the national insurance contributions if you are working, which you can apply for in the modern day, which will show you're paying into the sort of national insurance contributions every month. So that could be proof that you are working in the UK, payslips, contracts of employment, etc. If you're studying, university degrees, transcripts, along with your passport that you held at the time would be quite relevant as well. So we would look to help you cover the entire 3-year period, but where there are gaps, we'll probably rely on alternative evidence and try and get the UK government to look at approving the case on the balance of probabilities where there's not complete set of documents. So that's what we would do. And obviously we would have to do all of this and prove you resided in the UK for 3 years in a formal application before your child turns 18. Now, you may feel, oh, I've never had a British passport, but that's fine because not having a physical British passport does not mean you're not a British citizen. In law, you've been a British citizen, you know, with those assumptions all your life. So don't get discouraged by having to think that, oh, I need to apply for my British passport first. Not necessarily. You would have been a British citizen in law. So I'm hope that's given you some hope there. And why don't you approach us for some more information and a more detailed sort of examination of that claim? All right.
Okay, we're going to move on to Leon, who was born in Zimbabwe in 1983. Leon says he has a British passport by descent through his father. His father was born in the UK and his grandfather's parents were born in the UK. His mother was born in Zambia. and her mother was born in South Africa. Leon lived in the UK for 12 years, but he's currently living in Australia and has Australian citizenship. His daughter was born in Australia and she's 2 years old. So can she obtain citizenship?
Yep, sounds very promising, Leon. The fact that you've acquired Australian citizenship is neither here nor there. The Australians don't require you to renounce any British nationality when you take their citizenship up. So you are a British citizen by descent, but if you've got 12 clear years in the UK, provided that there's a 3-year period where your absences from the UK did not exceed 270 at that time, that's 3 months a year in short, then they're going to have or your child will have a claim to UK citizenship. Now, formal application needs to be made in the UK for that one with suitable evidence showing your past residence for at least a 3-year period out of your 12 in the UK. So theoretically should be fairly straightforward. Evidence can vary for showing that you're in the UK. It could be passports held at the time. It could be proof of employment through either records from Her Majesty's Revenue and Customs in the UK, or perhaps just an employer's reference from the employer themselves, or your pay slips at the time. Equally, if you're studying, it could be a letter confirming attendance from college, or even doctor's records, or that sort of thing you can use as well. So it can be quite varied in terms of the evidence, depending on what you were doing in the UK at the time. So, yep, that looks good. Something to get in contact with us for, and we'll be delighted to take that forward for you from the UK.
Great. Good news. The next question is from Nathaniel, born in the Ivory Coast in 1966. His mother and father were also born in the Ivory Coast. He says he naturalized as a British citizen in 2005. His daughter was born in South Africa in 2003, and her mother is South African, who lived in the UK for 3 years. His daughter is now 17 years old. Can she claim British citizenship?
Oh, okay. Yeah. I mean, thank you, Nathaniel. That's quite good information, and at least I think the important bit there is when you naturalized. Unfortunately, as I understand it, is that you naturalized in 2005, but your daughter was born in South Africa in 2003. So unfortunately, at that point, when your daughter was born, you were not a British citizen. Of course, had you been naturalized before birth, of course, this would be straightforward, and your daughter would be a British citizen. But unfortunately, when a grant of British citizenship through naturalization is given after the child's birth, it hasn't got any retrospective sort of effect on a child. Now, I do understand what that probably means is that your daughter doesn't have an immediate claim to British citizenship here. But one point to note is she is 17 years old, so still under 18 years old. And I don't know if you and her mother are together or not, and whether you're resident in the UK at the moment or not. But if a move to the UK was made before 18th birthday, then at least she could depend on your nationality, come into the UK as your dependent, or if you are married, as your wife's dependent. And we could look at how that would play out. Because usually, even though she would turn 18 while she's here, but she would get entry while she was under 18. And that would either lead to her getting her own nationality in a 5 or 6 year period, basically. So if you think her future lies in the UK, then the time to act is now. Obviously, there are a lot of things that I would need to ask you, but it's best to get in touch with me through a consultation, so I can ask you all these relevant things. Because obviously time is of the essence if a move to the UK is planned, because I don't see anything immediate, Nathaniel. All right.
Okay, I think one final question. There's one from Mark where it's a little bit more around naturalization and qualifying for that. It's my oldest son has been in the UK on an ancestry visa, but during the COVID lockdown, he was out of the UK for 170 days. Will this interrupt his claim for naturalization at the end of the 6-year period?
Straight answer to that one, no, Mark, it won't. The UK government have already published policy on this, and any time outside of the UK during the pandemic will not count against you in the calculations for whether you qualify for naturalisation as a British citizen. So that's already been decided. However, we suspect you'll probably need evidence to show where you were at the time, what was going on, and perhaps attempts that you tried to get back to the UK at that time to keep yourself within the time limits. But yeah, again, please get in contact with us on that, and we'll be delighted to take that forward for you when the time is right.
All right, that comes to the end of our Q&A, all the time we have for our Q&A for the webinar. I'd like to thank everybody for joining us. Thank you, Michelle and Phil. It was very informative.
You're welcome.
As you can see on the screen, there are a number of ways you can get in touch with us. You can call us in the UK, from South Africa or Australia. Again, you can get a hold of us on our website, Facebook, WhatsApp. With all the information that you have, the best way is filling out our free assessment. It is quick. We will get back to you. Thank you to everybody for joining us, and have a good evening.
Thank you.